Senator Ned Mwoko. I represent the good people of Delta North, Delta State. Mr. President, I rise to move the motion for the restoration of Aniocha North 2 State Constituency pursuant to Supreme Court judgment. The Senate notes that in 2014, the people of Idumujono, Idumuchuboko, Ukunzu, Uboba, Idumuogo, Ubodu, Ubulubu, Anioma, I'm sure that sounds familiar, Ogodo towns in Aniocha North local government area of Delta State initiated a legal action at the Federal High Court, Asaba, seeking the restoration of the Aniocha North 2 State Constituency. Also notes that although the Federal High Court dismissed the originating summons, the Court of Appeal, Benin Division, on the 22nd of November 2017, delivered judgment in favor of the people, ordering the restoration of Aniocha North 2 State Constituency and directing the Independent National Electoral Commission, INEC, to conduct election in the constituency. Aware that INEC filed an application for leave to appeal the judgment of the Court of Appeal at the Supreme Court, but the Supreme Court, in its ruling of November 29th, 2019, dismissed the application, thereby affirming the judgment of the Court of Appeal as final, binding, and legally non-appealable. Recognizes that INEC, in compliance with the judgment, convened a meeting with the stakeholders of the constituency on 19th of November 2020, pledging to implement the court's directive. Subsequently, INEC submitted a comprehensive report to the National Assembly for consideration in line with Section 115 of the 1999 Constitution as amended, concerned that despite INEC having concluded all processes for the restoration of the constituency and reminding the National Assembly of the matter through a court letter dated 17 December 2020, further action has not been taken to facilitate the restoration of the constituency, and disturbed that the delay in implementing the Supreme Court judgment undermines the rule of law, disenfranchising the people of the affected towns, and also denying them proper representation in Delta State House of Assembly. Accordingly, resolves to approve the restoration of the constituency as ordered by the Supreme Court. 2, approve the Independent National Electoral Commission, that the Independent National Electoral Commission complies with this resolution by ensuring that the restoration of Aniocha constituency Delta State takes effect in next State House of Assembly election after the current life of Delta State House of Assembly, in compliance with Section 115 of the Constitution of the Federal Republic of Nigeria as amended. Seek the concurrence of the House of Representatives in line with Section 115 of the Constitution. I so move, Mr. President. Thank you.
To be seconded, I rise to lend my support to this motion. Mr. President, ordinarily, this is a very straightforward motion. And I will urge my colleagues to support this motion, believing that this is democracy, and the wider the spread of the democratic space, the better for the system and the people involved. Mr. President, the abolition or suspension of certain state constituencies across the country has actually deprived the people of proper representation and caused a level of imbalance in the political equation of some of these states. And because INEC is a creation of the law, it is expected that once the court has ruled in favor of the restoration of suppressed constituencies, it should be taken as automatic. And so I urge the Senate favor of this motion and to urge INEC as a matter of urgency to conduct election into the affected constituency, believing that similar constituencies that were suppressed in some states have also been resuscitated and restored by court orders. And I want to say here, maybe when I come to additional prayer, to urge INEC to, as a matter of course, know that the suppression has become unlawful and depriving people of their proper participation in the affairs of their states and constituencies, and that INEC should ordinarily restore all the suppressed state constituencies across the country. I support this motion, and I urge my colleagues to support too. Thank you, Mr. President.
Before 1999.
Huh?
Before 1999.
No, what I'm saying is that, you know, we are ruled by the Constitution of 1999, even though as amended. So the INEC conducts election into state constituencies that are recognized in the 1999 Constitution. So my question is, was this state constituency existing in 1999, or was it just a creation of the court?
No, it's sorry, it was.
So who represented it in 1999?
I cannot tell you off my head.
Then why did INEC leave it out after that?
Mr. President, this is a Supreme Court judgment.
We're talking about the Supreme Court
judgment. We're asking
now
for the Supreme Court judgment to be respected and the election conducted.
You know,
this matter has gone through the High Court, Court of Appeal, and
in my
the Supreme Court.
state, for instance, and we have only 26 state constituencies recognized by 1999 Constitution. I think INEC had tried to delineate and to bring up to see whether each local government can have representation. And at the time they said maybe they would just add 4, but I don't know whether it was ever implemented because I think it passed through. So if it is the court that delineates state constituencies, then this, but this one is Supreme Court. This is Supreme Court decision. Who has more information on this? Joel.
My name is Senator Joel Thomas. I represent the good people of Delta South Natural District. Mr. President, I want to throw more light on what my distinguished colleague, Ned Woku, is talking about. These constituencies were in existence and there were members elected into those constituencies, especially in my own particular, we have such a case in...
Use your campaign voice so that we can understand.
Okay. We have a similar situation in Isoko, not local government. There was a constituency, after the 1999 constitution, those constituencies were removed. So we are in court to reinstate such constituencies because that deprives our people the opportunity, like every other constituency or local government, to have 2 or 3 constituencies. And for my own particular case, Isoko North, we have only 1 constituency in that local government, state constituency in that local government, which is bigger than most other local government that has 2 or 3 constituencies. So we are in court. And the population supports that. So what he's saying is correct in most places, especially in Delta State, sir. I don't want to throw more light. Thank you, Mr. President, for the opportunity.
A copy of the report that INEC submitted to the National Assembly.
Mr. President, that was submitted to the clerk's office. To the clerk's office, and I gave you a copy last week, Thursday. In your office.
Because if INEC had taken steps to implement the decision of the Supreme Court,
yes,
you are saying in your paragraph here that INEC, in compliance with the judgment, convened a meeting with the stakeholders of the constituency on November 19th, 2020 and pledging to implement the court's directive. Subsequently, INEC submitted a comprehensive report to the National Assembly for consideration in line with Section 115 of the 1999 Constitution as amended. It would look like the matter was thrown back to the National Assembly by INEC to enforce the Supreme Court decision. Please,
Mr. President,
let the leader.
Remember that maybe the SP could also remember that actually INEC wrote to the National Assembly, but then this matter was beyond just a resolution of the National Assembly. It's a matter that demands constitutional amendment. So I remember that this issue came before the constitutional amendment exercise in, I think, 2022 or so. And the constitutional amendment was made. We approved it at that level. But by the time when it came to the floor, in both either the House or the Senate or both, it failed. So unless this issue again, we will reconsider INEC to make another submission. Maybe the constituent, the current exercise of constitutional amendment, this matter can again be brought. But in terms of the substance of the case, yes, the issue has been debated. The Senate has taken its action, and INEC was also notified that INEC has taken action. But the issue is that unless the constitutional amendment is made on this matter, the Senate does not have that right through a motion, to treat this matter. It has to go through the constitutional amendment process.
Yes, this is Senator Abdul Ningi.
Senator Abdul Ningi, your point raised earlier is very germane, and the explanation also given by the former Senate leader is germane. What happened was, all across the country, there were issues related to this particular matter in almost all the 36 states. Consequently, therefore, it needs a constitutional amendment to have this particular, some of these issues sorted out in the Constitution. But because a senator of the Federal Republic has brought the attention to the National Assembly, it is important, upon all the information we have, to direct the Committee on Legislative Matters to look at this issue in particular and all other issues generally, so that as we move forward with our constitutional amendment, the Committee on Electoral Matters should be able to provide all those issues to the Senate, because these are not only issues of Delta. Even within Delta, the Stongo Center also said in his own constituency there was a similar issue. So rather than now, so that our discussion should not be academic, allow the motion to go through, direct the Committee on Electoral Matters to peruse through this information and come up with ideas of how to go about it going forward, and then within the realm of the constitutional amendment. That's my suggestion.
Now, when I looked at the motion, no, sit down. When I looked at the motion, it looks like it's not something we can cure with just a mere motion. Because if the delineation for the 1999 state constituencies followed enshrined in the Constitution, such as we have 774 local governments now. For any reason at all, if there were local governments that were created prior to 1999, for us to bring that local government back to life, we have to go through constitutional amendment of that section that mentions the totality of local governments recognized in Nigeria. That is why a lot of states have not been able to create local governments. So if the Supreme Court decision is in order, but it will require enforcement, not by one arm of the legislature, it will require enforcement by the two arms through constitutional amendment. So I think that we should refer this matter, in my opinion, to the Deputy Senate President and to deliberate and put it as part of the implementable items on the upcoming amendment of the 1999 Constitution, as will be further amended. Yes, the ancestor of the Senate, distinguished Senator Aniocha Abarebe.
Thank you, Mr. President. Dear. This is talking about a state constituency with regard to elections. It's not talking about the creation of a local government or amendment of a local government. So this is strictly an INEC matter. So the question here is, if the Supreme Court has made a pronouncement to INEC, why would INEC bring it back to the National Assembly? We do not create constituencies for elections. So I think we need to review this matter.
Why did we even require to pass through? Senator Karimi, please off the mic on Senator Issa Jibrin's seat.
Mr. President, I quite agree with your position on this matter. But the confusion is this. We all know that there are two ways to a kind of deal with any amendment to our laws, or constitution, either through the process of lawmaking, through amendment, through alteration, or through pronouncement by the Supreme Court. Once the Supreme Court pronounces, you know better than I do, because as a lawyer, you know that. Once the Supreme Court make pronouncement, it's like making a law. So in this case, there's a pronouncement by the Supreme Court that this should be done. And once you have that done, you know that as a lawyer, that must be implemented. So this is a problem. Even in the US, there's what they call judicial activism. That is, when the Supreme Court makes such a pronouncement, it becomes law. It becomes law. So as far as I'm concerned here, as far as this issue is concerned, if he's very sure that the Supreme Court has made pronouncement, then by our system, we don't need to go through another constitutional amendment, alteration, because the Supreme Court has spoken. We can only do to undo what the Supreme Court has done. So that's my position in this.
But the former leader, the 9th Senate, and then you people decided to take it to constitutional amendment. And then the two chambers could not agree, or even where he died. But at that time, it was still a Supreme Court decision. I get hearing what I'm saying. So I think that the Committee on Legal Matters, Judiciary Legal Matters, should work together with the Committee on INEC and Electoral Matters, and approach INEC with the Supreme Court decision. If it is clear, simplicity, the Supreme Court decision has not been attached to the motion, so we can't know what was actually ordered by the Supreme Court, because we can't vary the Supreme Court decision. We can only enforce it. We can only enforce it. So, Leader of the Senate.
Opinion on this. It's also driven by the provision of Section 115 of the Constitution of the Federal Republic of Nigeria's amendment.
Please read, and then...
Yes, and that was alluded to in the motion. Section 115, where the boundaries of any state constituency established under Section 112 of this Constitution are altered in accordance with the provisions of Section 114 of this Constitution, that alteration shall come into effect after it has been approved by the National Assembly and after the current life of the House of Assembly. Now, Mr. President,
please repeat.
Yes,
Senator Oko, I hope you are hearing. Because this will seek to alter the existing state constituencies in your area, this decision. So what the Supreme Court has done, a corollary to it is what the Senate leader is reading. Read it so that they can hear.
well, where the boundaries of any state constituency established under Section 112 of this Constitution are altered in accordance with the provisions of Section 114 of this Constitution, that alteration shall come into effect after it has been approved by the National Assembly and after the current life of the House of Assembly. In other words, Mr. President, if this prayer says through here and we approve this, it means it will proceed to the House of Reps for concurrence, after which the clerk to the National Assembly will now write to INEC,
We approach it by way of motion, or do we approach it by way of bill? Because if you are seeking to do alteration, alteration will require bill.
It's not alteration. It's not alteration because, sir, according to the Constitution,
it's not alteration, it's delineation.
Because there's a difference between adjustment of local government boundary and adjustment of constituency boundary. Adjustment of local government boundaries will require constitutional alteration. But what this will require is a concurrence of the two chambers communicated to INEC, and then INEC will implement on the condition that INEC will have to wait till the end of the current life of the State House of Assembly before it comes into effect. But it does not require constitutional alteration at all, because the Constitution has taken care of that. Thank you, sir.
Much. With profound respect to the leader of the House, for those who are lawyers, including Mr. President, it is said that the Supreme Court is supreme, is infallible because it's supreme, and it is supreme because it's infallible. If the Supreme Court was of the view that the National Assembly has any other role to play, it will not pronounce with finality in the manner that he reportedly did. I do not think that...
Sorry, we have a problem. You don't have the Supreme Court decision.
Yeah, that's why we are going to, sir. So I think the only weakness in the conversation is that we are taking Distinguished Senator word for it. And like you had ruled, I think the way to remedy it is for Distinguished Senator to try and get a certified true copy of the Supreme Court judgment. If it is true, and we all can read it and get lawyers among us to read it, the Supreme Court is not in its place to recommend to Parliament to do amendment. When it has made pronouncement, that is final. So I think all you need to do, Distinguished Senator Nwoko, is to comply with the request or the advice or the earlier statement by Mr. President that we get the actual copy of the Supreme Court. The presiding officer happily is a lawyer, and then we have Judicial Committee to look at it. But I do not think that the Supreme Court, if it is true that they have so concluded that it will be up to Parliament to amend, this does not require constitutional amendment, just in line with what the 80-year-old young man, 70-year-old young man, the birthday ball of last week,
as the Abarode said, sir. Thank you very much, sir.
Distinguished colleagues, Mr. President, I go in line exactly with the presentation of the leader. Mr. President, the Supreme Court has given a judgment. The Supreme Court will not go in detail to tell you how to implement the judgment. I know that we also have part of our rules as legislative compliance. The section provides that after that, because there is a distinction between delineation or adjusting constituency in local government and adjusting constituencies for purposes of legislation, especially houses concerning houses of assembly and other assemblies. In this case, it is INEC. INEC has done its part. After the Supreme Court judgment, I can see from a photocopy here, INEC wrote to Mr. President. Now it is left for Mr. President to take a decision and then also seek for concurrence from the House of Representatives. It is these two concurrent conclusions that will now get us to legislative compliance. And on that, the conclusion also is very clear. It will not be within this session. It will still go back to INEC to do the needful before the next election. So we don't need the Supreme Court judgment. The Supreme Court judgment is attached to the letter to Mr. President. Thank you, Mr. President.
Some of the important issues here. One is that there is a Supreme Court judgment. Two is that this has nothing to do with local government. This has to do with House of Assembly seat. Three, we do require the concurrence of the House of Representatives in this matter. Fourthly, Mr. President, I do have here a letter from the INEC chairman, Professor Mahmoud Yakubu. I don't know if you would want me to read it or not.
Is a letter for the Senate or for you?
You know, it is addressed to the National Assembly, the clerk to the National Assembly, dated 20th of January 2025. And it's a proposal for the restoration of Aniocha North 2 constituency. It's a kindly refer to my letter, and it says, having concluded...
Proposal for the alteration.
Sorry?
Proposal for what?
Proposal for the restoration of Aniocha 2 constituency. And they said, having concluded all the processes for the restoration of the constituency pursuant to the Supreme Court, to the judgment of the Supreme Court in appeal number SC/129/2019, INEC versus Akaya Humphrey, Okoli, and others. The Commission submitted a comprehensive report to your office for consideration by the National Assembly in line with the provision of Section 115 of the Constitution as amended. It just said, consequently, the Commission reminds your good office about the pendency of the matter at the National Assembly for further action. So there are attachments of various correspondence from INEC to the clerk to the National Assembly. Mr. President, this is a very simple matter. I can produce the judgment tomorrow for the benefit of the Senate, but I can assure you as well that you can take my word for it that there is a Supreme Court judgment, and I don't think it is proper that we should be deliberating or discussing whether to implement a Supreme Court judgment or not. We should go ahead and do the needful.
So why did you bring it to us if you did not want us to deliberate on it?
Mr. President, INEC chairman wrote to the clerk who contacted me that this has to be done. And it's not about us we're not making any new laws. It's for emphasis, it's a formality. It has to be done.
I think what goes in your favor is section 114 of the Constitution that says that the Independent National Electoral Commission shall review the division of every state into constituencies at intervals of not less than 10 years, which simply means that by 2019, even your state constituency was ripe for INEC to go ahead and delineate it. I may alter such constituencies in accordance with the provisions of this section, that is 114, to such extent as it may consider desirable in the light of the review. The Independent National Electoral Commission may at any time carry out such a review and alter the constituencies in accordance with the provisions of this section to such extent as it considers necessary in consequence of any alteration of the boundaries of the state or by reason of the holding of a census of the population of Nigeria in pursuance of an act of National Assembly. Okay, so we go to prayers.
Yes, Mr. President, that's a letter from INEC. Some of the important issues here. One is that there is a Supreme Court judgment. Two is that this has nothing to do with local government. This has to do with House of Assembly seat. Three, we do require the concurrence of the House of Representatives in this matter. Fourthly, Mr. President, I do have here a letter from the INEC chairman, Professor Mahmoud Yakubu. I don't know if you would want me to read it or not.
Is the letter for the Senate or for you?
You know, it is addressed to the National Assembly, to the clerk to the National Assembly, dated 20th of January 2025. And it's a proposal for the restoration of Aniocha North 2 constituency. It's a kindly refer to my letter, and it says, having concluded...
Proposal for the alteration.
Sorry?
Proposal for what?
Proposal for the restoration of Aniocha 2 constituency. And they said, having concluded all the processes for the restoration of the constituency pursuant to the Supreme Court, to the judgment of the Supreme Court in appeal number SC/129/2019, INEC versus Akaya Humphrey, Okoli, and others. The Commission submitted a comprehensive report to your office for consideration by the National Assembly in line with the provision of Section 115 of the Constitution as amended. It just said, consequently, the Commission reminds your good office about the pendency of the matter at the National Assembly for further action. So there are attachments of various correspondence from INEC to the clerk to the National Assembly. Mr. President, this is a very simple matter. I can produce the judgment tomorrow for the benefit of the Senate, but I can assure you as well that you can take my word for it that there is a Supreme Court judgment, and I don't think it is proper that we should be deliberating or discussing whether to implement a Supreme Court judgment or not. We should go ahead and do the needful.
So why did you bring it to us if you do not want us to deliberate on it?
Mr. President, INEC chairman wrote to the clerk who contacted me that this has to be done. And it's not about us we're not making any new laws. It's for emphasis, it's a formality. It has to be done.
I think what goes in your favor is section 114 of the Constitution that says that the Independent National Electoral Commission shall review the division of every state into constituencies at intervals of not less than 10 years, which simply means that by 2019, even your state constituency was ripe for INEC to go ahead and delineate it. I may alter such constituencies in accordance with the provisions of this section, that is 114, to such extent as it may consider desirable in the light of the review. The Independent National Electoral Commission may at any time carry out such a review and alter the constituencies in accordance with the provisions of this section to such extent as it considers necessary in consequence of any alteration of the boundaries of the state or by reason of the holding of a census of the population of Nigeria in pursuance of an act of National Assembly. Okay, so we go to prayers.
Yes, Mr. President, that's letter from INEC.
Some people have to go back to Zuba Rock to continue the tax reform deliberations. So we go into the prayers. I approve the restoration of Aniocha North 2 State Constituency, Delta State, as ordered by the Supreme Court in suit number SC 129. Those in support say aye. Those against say nay. The ayes have it. I approve that the Independent National Electoral Commission complies with this resolution by ensuring that the restoration of Aniocha North 2 State Constituency of Delta State takes effect in the next House of Assembly election after the current life of the current Delta State House of Assembly in compliance with Section 115 of the Constitution. Those in support of Resolution 2 say aye. Those against say nay. The ayes have it. Seek the concurrence of the House of Representatives in line with Section 115 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Those in support of Recommendation 3 say aye. Those against say nay. The ayes have it. Well, let me thank my colleagues for their contributions. Yes, Senator Farahonsi.
Mr. President, I have one.
For bringing this motion for the implementation of the Supreme Court decision, which is already existing, which cannot be ignored, and which must be implemented, and to urge the management of the Senate to get in touch with INEC immediately and to plead with you to also take it up with your colleagues in the House of Representatives so that there will be concurrence to these prayers, and thereafter the National Assembly will write to INEC to comply with the Supreme Court decision, at least for the next election in 2027. I think it's very straightforward. So I don't know why the 9th Assembly went into constitutional amendment and all that. It won't work, because that would mean going back to go and test the Supreme Court decision in at least 24 or 25 states of the Federation. And there's no guarantee, because every state has problem. So since you've taken your own to Supreme Court, it means that other states can take a cue from there. If there was an omitted state constituency, they can also go to the court to seek redress. And that's what the courts are meant for. So they can go and seek redress. So I thank you for bringing this to the fore. And I thank my colleagues for all their contributions. The Senate Leader, Deputy Senate President. I think the puzzle is resolved in favor of Aniocha, not to state constituency. Distinguished colleagues, there will be a meeting of the Power Committee immediately on the, this will happen on Thursday, 13th March at 2 p.m. Meeting room 439. But immediately after this, today, Tuesday, 11th, okay, and all the way to Thursday, public hearing, Public Accounts Committee will be meeting in room 4, White House by 3 p.m. prompt. Leader of the Senate, we have exhausted items on the order paper. You have wished to move for adjournment.
Thank you, Mr. President, and very distinguished colleagues. Having concluded